opportunity for a few programming notes before we get into the substance of the material. First, I want to welcome Judge Scola to the advisory group and to this program. Judge, you are the 16th member of the advisory group. Kendall has been on from the beginning as well, and Judge Scola, I hope you'll meet you and Kendall. Kendall's going to help us today with this program, and Bob, I hope that down the road in the future you will take a program and run it. My sister has already asked if she could teach with you, so watch out for Ellen, right? She's already planning ahead, and I will say that as many of you may know, Kendall Coffey is the former U.S. Attorney for the Southern District of Florida. He has a very prestigious and very good practice here, and he did a great job as U.S. Attorney. And Judge Scola, I believe, has left the bench. Bob, are you off the bench now?
I am. I took inactive status October 3rd.
Okay. Well, we look forward to hearing a lot more from you in every way, and we wish you the best of luck going forward. I mentioned Judge Scola and Kendall. Judge Scola is the 5th federal judge to join this program, including Magistrate Judge Dietrich Wilder and Judge Huck and Judge Moreno and Judge Altman, now Judge Scola. And I added up, I know this is a weird thing to do, but I added up the experience years. You're supposed to go to sleep, you're supposed to count your blessings. So I was counting the experience years between the judges and the lawyers, and many of the judges that served as very high-profile lawyers. Judge Milton Hirsch. We have the former president of the Florida Bar, immediate past president of the Florida Bar, past president of the Florida Justice Association, past president of the American Association for Justice, Kathy Rundle's office, and a whole lot more. We have the chief judge of the 3rd TCA, and the former chief judge, Rick Suarez, the present Ed Scales. It's really quite a nice group, and I may say parenthetically that when we got this going, Kendall and Bob, it was out of conversations with many of the judges and many of the lawyers about preserving, protecting, and advancing the skills of trial lawyers and getting everybody to be more comfortable as a trial lawyer and how to go forward. And I will say that it pleased me that I made 15 and now 16 phone calls with Bob, and everybody said yes that I called. All the lawyers, all the judges, the Florida Bar is represented, and I was obviously very pleased about that. So we have a great group and we have a lot to share. Today's program could go for 3 days. The amount of material, obviously, we're not going to do that. We're going to cut it to 2 days. But I do want to say that the next program we're skipping December for the holidays, is January 13th. That will be here in Miami. Then April, we have April, and May, we're going to move to Key West and try and incorporate some of the Monroe County Bar Association and bring some people from out of Miami who have indicated an interest in participating in the Key West program. So kind of excited about that. There's 2.5 CLE credits the Florida Bar is awarding, and to get that information, Carmen can help you on how to get your CLE credits. We got 2.5 CLE credits for the last program, and it was very well received. They're excited about this, and the bar is participating. On a personal programming note, I may say that on December 1st, we will be opening our front yard across the street at the Underline. The garden will be open there with a very well-known sculpture of Pablo Echeverria, which is already there, but they're building the park around it. And so we're going to have a nice ceremony in the middle of Art Basel. And so that program is underway, and anyone who has nothing to do at 1 p.m. on December 2nd, come to the opening ceremonies, and with Key West planned, we waited for the rates, the room rates, and the congestion. It's the boat racing weekend, so put that on your calendars, and we will get that out. So the first thing I want to say, I'm going to open up with some remarks, and Kendall's going to pipe right in with his experience from a different perspective. Judge Scola and Kendall, at any time during this particular meeting, if you want to just jump right in, I would welcome both of your thoughts and remarks. So today we're focusing on trial preparation, and it's a subject near and dear to my heart because I've done it a long time, and because it is so ripe for innovation and so ripe for creativity and doing things outside the box. I am a strong believer, after over 50 years in practice, I should say, that what gets recognition or gets results is doing things a little differently, to make yourself stand out from the crowd. And that's true, as we covered last month, also with business generation. You have to set yourself aside for good and strong reasons and valid reasons. So I want to talk a little bit about trial preparation and the opportunity to win your cases without formal discovery. And I don't know any other way to present that except to share with you in a sort of anecdotal case-by-case basis some of the things that have come up that have been good teaching tools and things that we've learned. This first part is really, everyone's going to participate, I hope. But Kendall, you and Judge Scola and all of us have seen what paper discovery gets you, how far it gets you when you send out interrogatories and requests for production and even requests for admissions. Oftentimes, and maybe most of the time, the responses you get back from opposing counsel, whether it's plaintiffs or defendants, it doesn't matter, the responses fall into the category of evasive and ridiculous. And I wrote down a short list. I'd like everyone else to see who can come up with the best, most ridiculous objection to interrogatories. So I want to share with you an experience of some of my that I can recall as I sent out interrogatories. Hypothetically, an interrogatory was, how much did your client have to drink before this incident happened, this particular collision? So it doesn't matter what the question is, the answers range from ambiguous, work product, will provide, did provide, can provide, see above, which is one of my favorites, usually on question number one when you ask to see above. There's nothing to see above. Beyond the scope, subject to discovery logs, previously provided, not applicable, and on and on with objections. But the most ridiculous one on the top of my list, about 6 or 7 years ago, I did a program for the American Bar Association, and I moderated the program, and it was mostly defense lawyers. It was a products liability program, but it was everybody. And so we were talking about discovery, and one of the questions was, in a request for production, was to provide the documents that would support what the theory of our case was, provide the documents that would support that the defendant had notice of previous incidents. And one of the members of the audience, who happens to be from a very large firm in Minnesota, said, well, we object to that all the time, right across the board. Because if you use the word document in your request for production or anything else, we interpret in the from the Webster's Dictionary, a document is a item that is more than 20 years old. And that's how that's how a document, so it doesn't apply to our case unless it's more than 20 years old. We're going to object because this document is vague and ambiguous. And I, of course, responded as a panelist. I said, "Are you serious? I mean, are you really telling me that because we asked for a document?" So that's right. It's our job to protect our clients, and we will not give you anything that we don't have to give you. So what happens after this back and forth of nothingness and spending a lot of time and a lot of money and maybe 2 or 3 hearings, if you're lucky, if you get the hearings, you then go to the phase of what do I do? I'm not getting any answers to my discovery. So my recommendation on the next area of success is to ask the court to appoint a special master, someone who can overlook this discovery dispute objectively. Now, if your opposing counsel objects to the appointment of a special master, I think you have to ask the question, why? I mean, who's the good person and the bad person, the good guy and the bad guy, or the good woman and the bad woman? Why would you object if you are being candid and forthright? Usually they say, well, my client won't pay for that. And then I pipe up, well, we'll pay for it. But after we get a ruling from the magistrate, a recommendation to the judge, I said, you may get taxed for all costs. So sometimes the special master approach works, and you get a little bit of progress with the special master, even if it's just to get more candid and better responses. So with this particular pattern of written discovery, which are all there in the rules about what you can and can't do, I went on a bit of a search and a bit of a exploration of getting discovery without written discovery and outside of the rules, but inside of creativity and inside of good aggressive lawyering. So my first, no, not my first, but one of my more effective approaches to this arose in a products liability case who I represented, where I represented a man who his name is Ed Lang, unfortunately deceased now, who was a short person, which is a politically correct way of saying he was a midget. But he was a news reporter, he was a sports reporter, and a terrific guy, incidentally, but he was very short, and he had a disease at birth called osteomyelitis imperfecta. And short story on that is, by the time he was 13, he had broken 136 bones in his body just by sitting down or moving or pumping things. He had a congenital bone disease. But he was a tiger and a fighter, so he wanted to drive and make a living. And he got a job as a sports writer. But in order to drive his car, he had to use a device called pedal extenders. These are devices that are tubes that fit inside of one another. They're hydraulic, and they allow short people to drive their cars to reach the gas and reach the brake. And that was Ed's way of getting around. The defendant who manufactured this was a company called Drive Master. And although Miami does not have many hills, like no hills, he was coming down off the I-95 ramp, the expressway from the airport, at a steep decline, I guess, and his pedal extenders stuck. And his pedal extender for the brake didn't work. He couldn't use his brakes. His pedal extender for the gas broke, likewise, while he was applying pressure. And he was basically in a runaway car going down the expressway. So he extricated himself from the runaway car. He jumped out the driver's side, and the car ran over him, which is not the place you want to be when you have osteomyelitis imperfecta. And he was seriously hurt, obviously. So I brought suit against Drive Master, who manufactured this particular device, claiming that it was a product defect, a design defect, and that it failed, and that it was not fit for its intended use. And DriveMaster had its headquarters somewhere in West Virginia. I mean, a place that didn't even have a name, but that was their headquarters. So I noticed after getting nothing from written discovery, I noticed the deposition of the DriveMaster engineers, designers, executives, person with the most knowledge, everyone you could, and the staff, the secretaries and the office staff. And I noticed it, and I recommend this if you can. Went to the judge and said, Judge, we want to take these depositions in the offices of the defendant. To which there was a very loud objection. Why? And I said, because during the deposition, there will be some reference to papers and documents and letters and things like that. And we want to be in the office, so we're not running back and forth from the Holiday Inn, which is about 25 miles away, to get this stuff. And after much discussion, I got an order from the judge, and the order said the depositions will take place in the headquarters of the defendant, DriveMaster, in a very rural, very remote place. And I had that order because, and I thought about the American Express commercial, and that day was "Don't leave home without it." And so I had the order, and I had the judge's phone number in my pocket in case we ran into a problem. And now the defendant's position, having this order in place, was we have absolutely no place and no room for you to take these depositions. We don't have a conference room. We don't have an office. You have no place to take these depositions. So I said, I'll just stand up. I said, or find a phone booth. I said, I don't care where I take the deposition, I'm going. I've got the judge's order. And, you know, a lot of pushback, but we went, and I get there, and this mom and pop, as they were categorized by the opposing counsel, this mom and pop operation was about 2 city blocks. They made not just pedal extenders, but they made all types of devices to assist the handicapped. And lo and behold, when we got inside, there was a very spacious conference room, and adjoined by offices of the administrators and other people like that. And so we were able to get video equipment in there and take a videotape deposition of the people who designed and manufactured and sold this particular product, pedal extenders. They had denied in all written discovery that there was ever a claim against DriveMaster for these pedal extenders that were defective. Never, ever, not one claim ever did they receive notice from government agencies, from private individuals, from consumers, from vendors. Never a claim, which seemed to me a little unusual, but I guess it was possible. So we got into the depositions. I deposed all the obvious people, the design, production, and all those people. Never a claim. Product's perfect, and you know, I had a little hint, a little idea that wasn't so. So we went on to the depositions of the office staff and personnel, right in the same suite. 2 very nice women, and I asked them, I said, do you have any files, either from the government or from private individuals, from distributors or vendors, that have any complaints about these pedal extenders, that they were defective, that they broke, prior lawsuits, not lawsuits, just letters of complaint? And the women said, yes, we do. And I said, well, where are they? And they answered, each one separately, in the next office in a file cabinet. So I said, would you go get them? Now this is all on videotape. I said, would you get them for me so we can attach them and I can take a look at them and ask some questions about these complaints? Now there's a lot of stomping and yelling, but we're on videotape, and so they went into their offices and came out with two files at least this thick of complaints and problems that have been reported. And they brought them into the office, and the opposing counsel grabbed them and put them in his briefcase, which I will never forget. It was a Samsonite briefcase with metal locks that go down. And I remember his initials, they were KK. Each lock had a K on it. And I can still hear the snap of the locks on his briefcase. Now, this is a very interesting afternoon because for a couple of reasons. One was that this gentleman was the grayest person I'd ever met in my life. His hair was gray, his skin was gray, his shirt was gray, his suit was gray, and his briefcase was gray. Everything was just gray about him, including his personality, which was extremely gray. And he grabbed them and put them in his Samsonite briefcase, snapped it and locked it. So, and then he put it on a seat and he sat on it. So now we have a situation developing. The best thing to do is to call the judge, because we have the videotape that we can play the back. Judge was not available. So we had a few words and a discussion, and since he was sitting on the locked briefcase, I asked the court reporter to make a label and to an exhibit label and to put it on his forehead. That he is now an exhibit to this proceeding. And I said, just put it plain exhibit, we're probably up to number 7 on his forehead. Which of course she refused to do and he refused to accept. But we did get to put it on the briefcase. We reached an agreement to put it on the briefcase. So my inclination about all of that, and of course the judge ultimately ordered that we got to see the complaints and the files, and ultimately they were supportive of our position and really demonstrated a deception, misleading. And I had a hunch even before those depositions were in the afternoon. I had a hunch even before that afternoon deposition that I was on the right trail. Sometimes it's just intuitive, that's who you are. And my hunch was supported by the hot dog vendor outside of the factory. And he was a very astute gentleman. And he saw me there. It was August, about 103 degrees, wearing a suit and a tie, perspiring outside to get something. There's no restaurant, of course. Perspiring outside to get something to eat from him. And I walked up to order my order, and he looked at my suit and tie. I was drenched. He said, "You must be a lawyer." Very, very astute guy, right? He figured out I was a lawyer. I said, "Yes, I am." He said, "You lawyers are here all the time." I said, "Well," what do you mean?" He said, "I'm always here taking these depositions." I said, "Oh, yeah, I'm taking a deposition." He said, "Yeah, they're always here. There's always, stuff going on inside." And I got my hot dog and my root beer, whatever else I had. I said, I think I'm onto something here. I would have called him as a witness, no doubt. So Ed Lang, a terrific guy, got his day in court, and the case turned out very well. And I learned that most of the valuable discovery you get is not necessarily through formal written discovery, because there's a game of evasiveness and dodging, but to get out and go do it in the field, which leads me actually to a point that Judge Scola has made, and many others. There's an article in your materials that Judge Scola just wrote. It's sort of his farewell, it seems to be farewell speech, called Judge Scola Warning That Jury Trials Are Disappearing. And we had already had this conversation, me and a lot of the other people on this panel, as a matter of fact, everybody on the advisory committee. And the point to me is you can't really do great lawyering from behind your desk. Or at home in your Lululemons. It just doesn't quite work. You've got to get out in the field and you've got to get out and feel the texture of your case a little bit. By Zoom, that same deposition would have been a zero. It would have been no deposition. It would have revealed nothing by Zoom. They weren't going to give me any information. I wasn't going to be there to feel the moment, meet the hot dog guy and all that. And so that's to the point. And the point is that there are times that virtual discovery, virtual communication is just fine. It saves a lot of time and it's valuable. But there are many times where you just got to go do it yourself. You've got to be in the room, as they say, be in the room. And that was just reaffirming to me the value of getting into the trenches and getting a better result that we normally would. So anecdotally, the Lang case taught me a lot. And I'll just quickly, incident of this topic, like many of the other topics and sessions, really could be many hours. I mean, many hours. I was going through some of my notes from other presentations. But there's a lot of reasons to go to the scene. There's a lot of reasons to do informal discovery. And I want to shift to one other area, well, a couple of areas quickly that we can cover, because I want to leave plenty of room for Kendall, very anxious to hear his thoughts. Some years ago, I had a case in Key West. My client was a 14-year-old handing for leadership named Katie Reed. Her sister Rebecca Reed, and she was cheerleaders at Key West High School. Her older brother was a police officer. Her mom was a single mom. They were a terrific family. And Katie, at the age of 14, was riding her bike, and a motorcycle ran into her and seriously injured her. And of course, the motorcycle owner operator had no insurance. And she was very hurt. So I went down to the scene in Key West on Donald Street, and I looked around just to see, usually there's a reason. Why does somebody run into somebody? It's the middle of the day. No one was drinking. Usually there's a reason why something untoward happens. And I looked around and I saw a line of fresh asphalt in the area. I don't know, I can't remember if it was 100 or 200 feet or more of just fresh cut pavement and asphalt on top. So I was curious about that. And I knocked on a few doors about that and found out that the Florida Keys Aqueduct Authority was in fact laying piping or pipes, whatever they put. And I further found out that that was what was going on the date of Katie's injury. And so I found the motorcycle operator and took his deposition or interviewed him, I'm not quite sure, and determined in this conversation that it wasn't just happenstance that he on his motorcycle, which is not very big, ran into Katie. It wasn't even a stop sign, but that the Florida Keys Aqueduct Authority was cutting the asphalt. The smoke was up in the air. There was a lot of noise, a lot of diversion, distraction, and it distracted him to the point that he ran into Katie. Now, the Florida Keys Aqueduct Authority and their workers or their contractors had plenty of insurance. So, skip to the bottom line, we had a solvent defendant who was negligent, and then we found out they didn't have up the appropriate work area signs and all the other things. And that case meant financial security for a beautiful young girl whom I'm still in contact with, and her sister. Her mom's no longer around, but I was invited to their weddings and felt pretty gratified about being able to help Katie and her family. So those are the type of things about getting out of the office. In Key West, there's also there was a Naval Air Base housing for Naval Air Base at Peary Court, which is right near the marina. And I had another very tragic case down there that a young child was run over by a moving van. Now, the other case, the asphalt cutting case, was defended by Bill Solms, who was then at Wicker Smith. Many of you don't remember him, but he was a very good lawyer and very complimentary, actually, of how the case turned out. This case at Peary Court was defended by Ed Corlett, Corlett Killian, or someone in his firm, which Rick Suarez was in many years ago. And this was a case where a moving van ran over a young child who was on a little tricycle. And so I went to the scene there too. I figured, let me take a look at what happened and make a long story short. As I drove into Peary Court, all I saw on the entrance to the location of this tragic event were swing sets and permanent toys and things. Everything spelled out children. They didn't need signs that said children at play, because the environment was children at play. And you can imagine what that deposition was like with the driver and how it turned out. Wouldn't have seen that or done that if I was behind my desk taking a Zoom deposition or not going to the scene. And I could go on with the not going to the scene. Even really, I can confess some mistakes on these, some cases that I missed and some ideas. But by and large, I'm a believer in trial lawyers being trial lawyers, and everyone who's here is interested in becoming a better trial lawyer. And the best advice that I can share about that is to sort of roll up your sleeves and become part of your case. So I want to switch practice areas for a moment. Having gone to pedal extenders and Peary Court and Katie Reed, when you ask the question of a defendant doctor, you hardly ever get the right answer. But I have tried with some success to ask if we can take the depositions of defendant physicians in malpractice cases in their office. Now, usually the client, the defendant, says, fine, I don't want to give up 6 hours of my day going to a court reporter's office or to plaintiff's counsel or to anyone. So he says, fine. The lawyer, sometimes yes, sometimes no. So what's the advantage of why am I doing that? Why am I trying to take the depositions in the offices of the defendant physician? Well, a couple of reasons for doing that. But one of them is that one issue in medical negligence is what sources do you consider to be authoritative in your medical field? What books, Campbell's Orthopedics, what is authoritative? And generally, the answer you get if you're sitting in your office and they're in your office is, well, nothing is authoritative, really. I mean, it really doesn't matter. I just kind of know what to do, and I'm really authoritative. So before I take a defendant doctor's deposition, and I would recommend this, it's all fair play, do your research. Everything is online. Find out where he or she went to medical school, find out what courses they took, it's all there. See if you can find out the professors who were there when the defendant was there, and to keep people straight in answering questions accurately and fully. I usually start out with a question that gets their attention, such as, did you study with Professor Portman when you were in medical school? And then they look at you, how would you know that? And I said, was the textbook you studied this particular textbook? And they look at you and say, well, how would you know that? Well, from that point forward, you're getting a much more responsive witness. They kind of figure that you've done your homework, and it's sort of a shot across the bow, and you can go on. The other thing about this is a medical negligence setting, each one of these vignettes, each one of these things really is the subject of an individual seminar or an individual conversation. So while you're there and you're on the topic of what's authoritative, and what you recognize, the physician's sitting in his office happily not wasting his time, and you're there, and the court reporter's there, and the videographer's there, and you can ask the question, Dr. Roberts, I see on the wall behind you, you have a number of very detailed looking textbooks and medical journals. And yeah, I said, would you mind if we videoed those and have them, on our video to see, if they are in fact an authoritative source? And would you have a book in your office that you would refer to that was not an authoritative source? Well, either answer to that is not very good. I have them there for decoration and I don't read them, or I do read them and they're authoritative. I mean, and there's, hardly anything in between. They're either decorative or authoritative. So there's usually an objection to that. You didn't notice this, and it's not this, not notice produced. But either way, it raises the question of what is an authoritative source. Now, I had a case, and this gets me to requests for admissions and how I use them a little differently than other people do, but maybe other people do, and I don't know, because, I don't know. And so this Dr. Roberts, who is a plastic surgeon, was doing a facelift on my client in his office, and he had the phone cradled, his cell phone cradled between his ear and his shoulder while he was doing the work on the patient. And now he didn't admit to that, but one of his staffers did admit to that. And your client, who is with plastic surgery, is not really under. I think you have to be awake to have the right result. And I think she said, she noticed he had the cell phone cradle between his ear, and he was talking to his stockbroker about a financial investment. Now, this is fairly callous stuff, right? I mean, most people on the jury wouldn't want their doctor on the phone talking to their stockbroker while doing the facelift. And so in a request for admission, in this case or any other case, one could ask, do you admit that you had your phone cradled between your ear and your shoulder while you were performing this surgery? Now, that's a request for admission. I admit, I deny. And the next thing I do, which there's usually some sort of resistance to, but it's allowed, is I say, if you deny the above request for admission, and I do this in an interrogatory, if you deny this, please state every witness and every document that will support your denial of this request for admission. All the witnesses and all the documents. Now, you can do that with any question. If you deny that you were drunk, if you deny this, if you deny that, if you deny anything, an interrogatory follows, and that interrogatory can clearly be something that nails it down a little bit. There's another long tail story about this particular case. Like I said, we could be here a very long time. But apparently, even though the phone was cradled, he didn't do any damage to my client. He didn't cut a nerve. He didn't do anything medically or operatively wrong. And no one, and she had been to 6 other physicians, no one could find anything that he did wrong. My client had intractable pain after the surgery, and for more than a year, she was in immobilizing, incapacitating pain. And no one could figure out the reason for it. They severed her trigeminal nerve to see if that would stop the pain. That wouldn't stop the pain. They gave her she was taking all types of medication, all types of painkillers, all types of injections. The pain was disabling. So my senior partner at the time, who was a very bright man, Bill Frakey, so I quote, he said, there's a reason. You just haven't found it. he actually wasn't that nice about that. He was a tough taskmaster, but that was the message. You just haven't found the reason why this woman's in intractable pain. I said, but Mr. Freitas, I've been all over the world. I said, I've done all the research and everything else. He said, well, just find the answer. So I did a little research, and it turns out that this fell into the category of phantom pain. And that is pain that an amputee in a war situation may feel if they've lost a limb. The limb isn't there, the pain is still there. So she went to Duke for some medical treatment, and I then went to Duke to speak to her doctor, and who was very helpful. And no hot dog stand there, but I did have lunch. And he said, here's the story. This is either psychosomatic or psycho something or other pain. It's real. She really feels the pain. And this pain comes from a person who she was relying upon and counting upon to make her more beautiful and to take care of her surgery. And this was a form of abandonment or rejection or indifference to her situation she was going to face with. And this is where her pain came from. It was a psychological pain, nonetheless real. Well, it turned out that he was a Duke psychiatrist, and I got a little bit more supporting evidence, which I don't think I get by Zoom or over the over the screen. And he was right. So in the medical world, that is a little vignette that kind of sticks with you. Now, the problem is, I was explaining to Evan just before we got together here, the problem is that, we have 16 people on this advisory board, Scola, Coffey, and all these other. Everybody has great stuff. Great stories, great vignettes. The judges will tell you what the lawyers did wrong in court. The lawyers will tell you what the judges did wrong. It's all this volume of really valuable history. And I can't figure out a way to share it, to get it out to the next generation of trial lawyers or present generation trials. It's like I could go on forever. Justin was kidding with me. He said, you're not even going to prepare for this talk, are you? I said, right. I said, I've been preparing for 50 years. This is the real deal. And so that's something that I hope Judge Scola and Kendall and the other folks, Judge Moreno and Judge Huck, are very interested in this. And Fred Lewis is my co-chair, former Chief Justice of the Florida Supreme Court. He's been on this. He teaches in law school. H.T. Smith teaches in law school. Lonnie Rose teaches in law school. All of them have the same feeling. It's sort of like pass the baton. What are you going to do with all this knowledge? The answer is I don't know. This is a good start, a little start anyhow. So there are other practice areas that bring up other little vignettes, and there's one that I'd like to get into, but I'm not going to right now because I want to hear from Kendall. It has to do with cruise lines and discovery in that realm. We can do that privately. And the other one, I spent 13 years of my life litigating against Japanese manufacturers exclusively. All I did was discovery against Honda, Suzuki, and the Japanese motorcycle and ATV manufacturers. And it was about defective parts on ATVs and motorcycles, but it's a 13-year voyage, and how informal discovery won a slew of cases, all of them, against this particular industry. Suzuki and Kawasaki and Honda were not big fans of mine. I took 13 years with depositions through translators in Japanese, mostly in Orange County, California, literally moved out there. So that's the subject of another conversation, but a good one nonetheless. But I want to turn it over to Kendall, because his perspective is obviously going to be different than mine, and probably more objective and better and less of war stories. But Kendall, can you just jump right in here, and then Bob, you too?
Yeah, be happy to. Ira. I may slip out a little bit early. I've got a flight out tonight, but I've enjoyed your comments immensely, and I'm sure everybody's been paying close attention. There's almost nobody among the lawyers in this community that I admire more than Ira, so it's quite a pleasure to be here. And I can just say this about Judge Scola. Once I actually had an opportunity to kind of check up on him, and I have to say, I heard from lawyer after lawyer that he was the best trial court judge they ever appeared before. So we're all very fortunate to be part of this tonight. And I want to tell you about last night, because last night I was part of a panel on the Bush versus Gore recount litigation. And probably not all of you are very, very familiar with that. You've heard of it, you've read about it in the history book. But what I was struck by is all 6 of us on the panel had remained good friends and were good friends. And that's valuable. And when you get into this journey of a trial, you got to be aggressive. You got to do your utmost. And that's the word I use when I talk to our lawyers. Do your utmost for your client, within the rules, of course. But remember that you and your adversary are going to be on the same airplane that's maybe bouncing around in some turbulence together. And you want to create, as much as you can, a positive relationship with your adversary. And again, if they're cheating, if they're lying the way some of the folks that Ira described, it gets tough. We got plenty of cases where it's tough, but it serves the profession and it serves you, because I've got to tell you, your adversary of today could be somebody that hires you a year from now or sends you work, or somebody, if you're applying to be a judge, and I hope a number of you are, comments on your fitness and your qualities for judicial office. But just importantly, when you look at the stress of a trial, and it is stressful, this isn't an easy line of work. You got to really love litigation, I think, to be a successful litigator long term. But when you're working together, at least with civility, if not cordiality, it makes the process easier. It is something that I think is perceived very favorably by the court. And remember, whatever you're doing in your practice, every day, and this is a line from Judge Scola that I heard at a seminar years ago, you're making your reputation every day. Everybody you talk to, everybody you offend, everybody you impress, everybody, every interaction, every day. And as lawyers, that's what we got, our reputations. It's not, we don't own factories. I mean, most of us anyway. We don't have hard assets. We've got our reputation. So one of the things that makes this difficult business of trying cases much, much less strident is trying to establish a positive relationship with your adversary, even if it's not easy, even if it's not. And we've had plenty of cases where that's been difficult. We've also had cases where the other side's client was a skunk, but the adversary conducted himself or herself with professionalism. And we remain very, very respectful of each other. Now, the topic, and I don't want to spend too long on it because I think it's important that we hear from Judge Scola. The topic is preparation for trial. And we know that as lawyers, we say it depends. And it can depend somewhat on the nature of the trial. There's all kinds of trials. We think of the great excitement of our profession is the jury trial for a lot of reasons. And of course, jury trials can be federal criminal cases, which have a lot of differences from a state court civil cases. But beyond that, you will be trying cases maybe in the bankruptcy court, where it's just a judge. And of course, the federal and state courts have a number of cases which are just tried to a judge. And some of you may have an immigration practice. There's an immigration court, which you know about. And those are like real judges, although they're in a complicated position nowadays. But they're judges who try to get it right. And different kinds of trials. What about an emergency injunction hearing? That can be a big part of especially commercial practices. But that's a kind of case where you compress everything, and in 1 week, maybe 2 weeks, all of a sudden, you get a result. Thumbs up, thumbs down on the temporary injunction. And that can be effectively case dispositive. And local government practices often provide occasions where you have to build a record. in a zoning case, for example, where you get some opportunity to question the other side. That's a different kind of trial. But I think they all come down to, and obviously jury trials have significant issues in terms of, do you hire a jury consultant? What's the strategy for voir dire? Do you even pronounce voir dire? Is it voir dire? I'm not sure after all these years. So there are differences with a jury trial, but they all come down to, I think, what are your best facts? What are the small number of facts in your favor that are going to drive the outcome? And that's something that I think from the first moment you meet with a potential client till the verdict and the final appeal is done, that you're thinking about all the time. And you have to be prepared to know that what you thought were the key facts can evolve over the course of a trial. Don't be tone deaf. Listen, and maybe kind of update what your impressions are. But that's what drives it. And just to get back to a couple of things Ira mentioned. Yes, go to the scene of the crime or the scene of the malpractice to the extent you can, or the other side's headquarters. Or if the case involves real estate, go look at it. If the case involves, years ago, I had a case we were challenging a new banking application. Sounds kind of boring, but important to the client. But we drove out to the locations and we drove all around to try to get a real sense of things. So Ira's point about getting kind of a direct visual of the subject is very, very important. I also felt deeply sympathetic as Ira was describing the obstacles that folks put up. And it's not just defendants. It's kind of like an unfortunate growing trend that almost seems part of the culture for many, just making discovery difficult, because if they wear you down, you're going to get less. And if you get less, you're going to be less effective. And boy, the answer for that is not an easy one. All I can say is you've got to be tenacious. You've got to be determined. You've got to keep going and recognize the fact that some people will cheat, even with the nice smiles and the impeccable courtroom decorum. And you've just got to keep going. Now, one thing I try to do is rely on it, because I do much of what I do is in commercial cases nowadays. Third-party subpoenas. Why third-party subpoenas? Because, it's a third party. You're getting bank records. You're getting maybe records from another person in a joint venture. You're much more likely to get reasonably prompt responses, and you're much more likely to get accurate responses. So I try, and that's one of the things I do and preach, is get early on the case with third-party subpoenas, because getting the same documents out of your adversary might be infinitely more difficult. An investigation. I mean, a lot of commercial litigators, they do, as Ira said, kind of sit at their desk. They send out the paper, and then, of course, they participate actively and effectively in depositions. But what kind of maybe there's some room for investigation, including hiring private investigators, including, obviously, whatever you can get on social media, because sometimes there's stuff, there's plenty of stuff. And of course, that can also include a painstaking search. This will require subpoena into phone records. I'm telling you, a lot of times you ask the adversary for phone records, all messages, texts, and stuff like that. You get next to nothing. And then if you can go to the trouble to search, get subpoenas issued to the carriers, you start to get some things. And if nothing else, you can certainly find out that there's a high level of phone contact between different folks. Sometimes you can actually get some of the records. So tenacity, skepticism of the other side's responsiveness, those are some of the qualities you have to have. One thing that is traditional discovery that I really advocate in terms of trial preparation is videotape depositions. My gosh, how many times have we seen a case where somebody who's got a snide, evasive attitude gets up in, full Technicolor on a screen and looks terrible in front of the jury? And even if there's good testimony you've got from an adversary, maybe you still want to put it on a videotape rather than just have them just say it in courtroom, because there's some studies that indicate a person's image and words on video are much more closely attended to than sitting in a big courtroom where they're just sort of part of the landscape as opposed to the entire focus. Again, coming back to what are your best facts? How do you assess what your best facts are? How do you prove your best facts are? How many times do you repeat your best facts at every opportunity, every turn in the case? Because you don't know how much it's absorbed, but you have confidence that it's a message that is going to resonate. What about just the logistics of preparing for a trial? Assuming you've done everything, you're up to speed on discovery, which is obviously one of the most important things. When it gets closer to trial, there are a couple of things you really need to think about. One is really exhausting the possibility of settlement, because trials, now what I do is mostly hourly stuff, and there's criminal cases that are fixed fees. There's of course personal injury cases, which are percentage based, but trials are shatteringly expensive for the vast majority of clients. And so it's extremely important whenever you get sort of closer to trial or within shouting distance of a trial, maybe a couple months, that you go through that again with a client. And if you're looking ahead, and I'm not always looking ahead, you build into your fee agreement a trial retainer, because trial needs attention on a professional standpoint, but it's also very important from a firm business standpoint to make sure that the firm is going to be protected and the client's going to be protected and doesn't have complete sticker shock at the end of the case. And we all know that most cases are going to settle, and a big reason of that is expense. But please make sure at different intervals you are discussing settlement, keeping an open mind to settlement at every turn. I don't see it as a sign of weakness. I've seen it, and many people do. Well, if I, act like I'm open to settlement, I look weak, and I want a warrior with a giant spear, not somebody who's being accommodating. Well, look, you can still be aggressive and fight like crazy and be open to a reasonable settlement, because it's very, very hard to guarantee results. And all of us who've been doing this a while have some shocks. So a couple of things as trials looking closer. Make sure you're lined up with the right people for your team. And a lot of times that means support staff that's going to handle exhibits, or support staff that's going to handle the electronics. Trials now almost always, at least in what we do, involve some significant degree of visual stuff on a screen. And so that's got to be handled smoothly. And there is a lot to the logistics of a trial that has to be handled smoothly. You don't want to flap around. You don't want to lose the momentum of your flow because you're scrambling around to look for an exhibit. All of that logistics stuff is really important so that you can concentrate on delivering the message through the witnesses and through the documents. So definitely make sure that that's organized, that that's thought about, that in advance of trial, that when you show up, you're going to know what the most important exhibits are. You're going to know the numbers. You're going to be able to find them with more or less a snap of a finger. You're going to be able to find the page and the line in the deposition of the opposing witness where he or she just contradicted themselves. All of that takes planning. I'm putting it under the broad banner of logistics, but it's fundamentally a key element of trial preparation. Jury trials. Do you get a jury consultant or not? And I'd be interested in Ira's experience. Actually, I would want Ira to be my jury consultant. And but many people believe that you kind of win or lose your case with whoever's on the jury. And how do you get a jury that you think is not going to be prejudiced against your client? Is going to give you a fair shake and a level playing field. It's not so easy. I think and some might disagree, that most jurors want to sound fair. Most jurors want to minimize their prejudices, their inclinations. And it's not easy, even if you had unlimited voir dire or voir dire, as you used to in the old days, where the judges would let you go on for a pretty long time. Not so much nowadays. But even then, that doesn't mean that the jurors are going to really tell you what they feel. And there's a lot of studies that show that their pre-existing experiences and conditions are much more important than the questions you're going to ask them in the course of voir dire. So how do you get the right jury for your case? Not easy. I've been at it not as long as Ira, but I still haven't. I still can't guarantee that I get that one right. And I've had a couple of situations where, fortunately, they were cases of a directed verdict, so we didn't have to hear from the jury. But those were cases where I got it wrong in terms of what I thought would be the logical jury for my case. But definitely make sure you go through with your client. That is an option, a jury consultant. I can't give you a list of who's good and not. I can tell you that lawyers who have been doing this a long time think we're pretty good jury consultants ourselves, but sometimes somebody who's separate, who's not part of what you've been going through, is a very, very valuable person in that dynamic. And it's a cost element too, because obviously it's something that can have a cost. Jury instructions. One of my partners says he likes to do them early on, well before the beginning of trial, because if you're writing up your jury instructions, and some of them are just standard form juror instructions, but some of them are significant. If you do it early on, it helps you kind of shape some elements of your strategy. Do jury instructions matter? I think so. Not in every case, of course. A lot of cases, it's who's right, who's wrong, who was reasonable here, who's unreasonable. Negligence cases, a lot of them may not have important jury instructions. But I've been in some cases where I thought it was case dispositive, including a federal criminal case where we got an instruction about something called specific intent. So jury instructions, obviously there's going to be a point in time when they're due under the court's pretrial order, but think about doing them early on because they help you kind of shape your strategy. Motions in limine, you all know what that is. My observation is I think they're somewhat underutilized. They're things to exclude or include evidence. They tend to be, in my experience, sort of last minute afterthoughts and, not with a lot of citations and stuff like that. But think about how to use them and do it well in advance of the trial, because it isn't just limited to a single issue like photographs of the surgery be shown or something like that. Sometimes if you think somebody's got a key witness, you can go through their deposition and you can itemize hearsay in the deposition before trial or itemize other things in the course of the discovery that you think the other side is likely to use. And you can ask that be excluded. Why do you want to do it in advance of trial? Well, otherwise it could just blurt out during the trial. You might miss the objection. So motions in limine can obviously be used on big things, but they can also be used if you sort of, kind of go through the discovery and see what you think are some items that may be heading your way that you can exclude in limine. And of course, motions in limine can be very, very important. A lot of times judges push back on them and say, well, let me see how it develops at trial. Fair enough. They don't want to rule. I got it. They want to look at the issue of admissibility in the context of the total trial, which is a reasonable position. But on the other hand, you're informing the judge of your concerns, and if they're legitimate concerns, it's not a mistake to let the judge know that. A trial tends to be what? Evidence, exhibits, and witnesses. And we're all list makers, I think. So obviously you're going to be listing the witnesses. Make sure you identify what you think are the key elements from each witness, as well as, of course, the little stuff. But most witnesses have a modest number of things that you really are paying attention to, both for purposes of cross and for purposes of direct. So make sure you understand what those critical things are, and that you focus on them. There's mechanics about getting out your subpoenas well in advance. Daubert motions, you all know what that is. Like motions in limine, you need to be thoughtful. They should be researched. They shouldn't be pro forma, and they should be done at the latest with it by the time of the court's deadline. But sometimes early and sooner is better than later. Just a couple thoughts, and then I want to hear from our other distinguished guests, or our other very distinguished guests, as well as Ira. What is the strategy of opening and closing? As I said, you start to think about your opening and your closing from the first time you're exposed to the case. I got some advice on openings, and I think closing's a little different, because you really have to focus on what was the evidence at trial. Hopefully you're a good listener and a good observer, and you have some sense of where the jury is, and that should heavily shape your closing, I think. But what makes an opening good? Some studies have shown that juries decide the case or have an inclination that turns to be their ultimate decision in a high percentage. In other words, it's like opening determines a lot of cases. I'm not sure if it's that way so much as opening reveals the key facts from each side, and the key facts from each side are what are going to drive the outcome. But years ago, there was a guy who used to set the records for personal injury verdicts named Murray Sams. And he went over to me. We're trying a case together. And I was doing the typical, I don't know, what I'd read in the trial manuals or seen in the seminars, which is have this theme, tell a story. And his advice to me was as follows: get to your best facts quickly in opening. Don't go on and on and on and on and build up to them. Get to them quickly. Why? Because that's when you've got the jury's attention still. The best facts are going to drive the income, and the best facts are going to drive you. When you have some good facts to work with, and you start to talk about them, you get animated, you get energized. You're not just focused, but you feel a forcefulness about your presentation. Go to that early on. Go to your best facts, and early and often. I'm going to conclude with just this observation. It is one of the greatest privileges we have to be lawyers in litigations in this country. It's not just about rule of law, it's about individual justice. And you don't really have it in 99% of the rest of the world. And so the kind of things Ira's talking about, challenging giant companies that are unscrupulous, good luck trying that out in the vast majority of countries here, where they protect the giant companies. They make justice for the individual even more difficult than it is here. So we have a great privilege. I think we should feel blessed every time we set foot in a courtroom, good day or bad day, honorable adversary or jerk. Either way, it's a great privilege to be part of this system, and it's a great privilege to be here tonight with Ira and with Judge Scola.
Kendall, thank you very much. Judge Scola just sent us a note, and he's absolutely right. He really just joined this group about 3 or 4 days ago, and he has plans that are set. So he's going to run. I'm going to ask him and you and others to run some programs in the spring. Bob Scola is a real asset. So he's tremendous at common sense, and he's a real judicial scholar. So Kendall, we thank you for your wisdom, for your participation, and you're my longtime friend, and I'm very pleased about that and proud of you. So there we go. And what we'll do here is we can take some questions if anyone has time about anything that we've touched upon, or the program itself, or suggestions about maybe some other things we should do. Anyone have a question or a thought or a comment about how we can do this better? Is there a better time of the day to do it that works? Would the noon time be better? Is this a good time? What do you think? Sarah, what do you think?
I prefer the later time. When
Yeah.
I go into the office, I'm in it. I won't leave for lunch.
Right.
I'm in my zone. I eat at my desk, and so I much prefer after work.
So this works.
Perfect.
Yeah.
It's
Okay.
on my way home too. It's lovely. Thank you again for having me. This
No,
is
it's
pleasure.
it's really very enjoyable. Works for us too to be here right on Dixie Highway. The traffic is now giving up a little bit. And we're going to take a group photo. But before Sophie's around with the camera, but anyone else have any other thoughts or really suggestions about how we can? Yes, please.
I myself don't even listen to podcasts, but when you said that you didn't know how to get, all these stories out, I felt like you can do podcasts. And
Yeah.
Yeah. It's interesting because we work with a company that suggested that we do that. We do some
Yeah.
podcasts. And maybe that's the way.
I listen to you on the drive into work.
Well, thank you. Thank you. With the news being so gloomy sometimes, maybe it will be good. I think I can do that. There's so much. If you looked at my outline, I didn't make any notes, but if you look at my outline, there are 3 or 4 topics just for tonight that I didn't get to. And it's like I feel like doing an all-nighter, and just I have a list of some of the cases that I think were uniquely interesting, and some that were, things have changed a lot. I'm sorry about my back. I think I may move over here. Things have changed a lot. Surveillance, closed circuit TV on so many of the cases have made it easier. Just about every event is on surveillance now. That's made it easier. Some of the things have made it harder. But you can get so much information online today, and now with AI, it's a great source. I mean, it's almost like, why bother with interrogatory number 14? It's just like, I mean, it's all there, and I didn't get into it, but yeah, we need to do more. I want to make sure that the program is accessible to everyone and to more people. We've got some people that were with us last time that are with us this time, and we're going to give a break in December because there's a holiday party or Christmas party, but we're back January 13th, I think. And the topic on January 13th is the anatomy of a trial, which is a good topic. And remember, we have at least 5 federal judges and a bunch of state court judges. It's going to be a good run of from now. I have it planned from now until maybe May or June. I think May we'll maybe do in advance. We'll do the Key West trip. Sarah, we can work on that a little bit. Sarah is the head of the Cole Scott firm in Key West, but our offices are right next to each other, so we save a lot on postage. We don't have to mail anything. We just walk. And may I just say parenthetically, I didn't mention in the opening remarks, but in addition to, I think what is a pretty stellar group of men and women, we also have 2 of the managing partners of 2 of the largest firms in town, Greenberg Traurig and Cole Scott, largest firms in the state, I should say. So I'm kind of excited about all of this now that we have the format for it. I'm excited about going forward, and you all spread the word. Bring your friends next time. We'll make room for them. We tried to keep it small, but we did. But inclusivity, I think, is much overlooked in life, and I think it really goes a long way to be inclusive. And here at our firm, I mean, Justin's here and Evan's here, and I mean, there is no secret sauce, really. It's just doing what has worked well and avoiding what has not worked well. And it's a learning process. Justin, did you want to say anything? With my partner here, who I can't say enough about, to be quite candid with you, he and Evan both are here and make my job so easy during the week. Anything you
Yeah, well, I just want to, first of all, thank Kendall. That was absolutely wonderful. And thank you, Kendall, as well. Just to very briefly echo some of what Kendall had to say about tenacity. You know, one of the reasons you have to be tenacious in the discovery process is a lot of the times you're going to draw these objections just because they think you're not going to follow up on them. You know, let's object to everything. They'll probably never get back to us. Sarah, as a very experienced defense lawyer, you probably see plaintiffs who never follow up on your object. Never.
I had one now recently and he said, your PFS expires. I need this discovery. I said, well, you should have thought about that 29 days ago. I'm sorry, my objection stands. Maybe I'll get it to you next week, but the PFS expires today.
As soon as you get the objections, you know, I'll get objections, I'll read them, I'll send that first email asking for a conference within minutes of getting the objections. I don't put it off. You have to follow up on it. And don't get discouraged when you draw all those objections. There is so much obstruction in what we do on both sides in every practice area. When I was a younger lawyer, I used to drive home in my car and there'd be steam coming out of my ears. How could they object to this? This is a standard interrogatory. And over time, I just smile now. Okay, you want to play that game. You can run, you can't hide. We'll set it for hearing. We'll move forward. I'll have a very brief conference with you because if you're dead set on being an obstructionist, we'll take it to the judge. I'll make my paper trail so I look like the reasonable one and it doesn't upset me. And some of the younger lawyers who get those objections, Evan, sometimes it is discouraging until you realize this is all silly. There's a judge who's going to set the record straight for you, get you your stuff. Just be reasonable. And don't ever get discouraged from being that tenacious lawyer that you need to be to get what you need to advance your client's interests.
And there's something to be said about getting along. There truly is. I had a hearing, a trial in front of Judge Jackie Scola in 2018. And we get to trial and she said, I've never even seen you guys at a hearing. And I said, Judge, we worked everything out. We're here just for the trial. And she said, that's great. I hate hearings. I hate going to motion hearings. I want to go to trial if we need to, and I want to get along. And for the most part, I'm friends with a lot of plaintiffs' lawyers. And, we work it out. We have a job to do. We defend our client. You bring a case for your client, and we do what we have to do. And I'm not going to pick my battles. I know what I need to get to trial. If it's something important that I need to win at trial, I'm going to go for it. And I know what I'm going to lose at a hearing. I have one client who always wants me to say, no, fight for the surveillance, we're not going to give it up. And I say, they're entitled to it. I'm going to lose, and I'm not going to lose credibility in front of them. We're giving it to them. So you have to pick your battles and get along. Listen, if you don't have to fight for it, don't. You're going to look bad in front of the judge,
But Sarah, that's the culture and the spirit of your firm, both Gene and Richard. I've sat at this table with Richard, just he and I, and settled 7-figure cases.
Yeah.
The two of us. I say, here it is, Richard. But one time or another time, I brought in the client for him to interview. I said, these are going to make great witnesses at trial. Now they were, but it is the approach of your firm. It's how you serve your clients without huge unnecessary costs.
Thank you.
So no, it's true. And Kendall, are you still with us?
And he made a note